Hey, shalom to you, man. First of all, my name is Dion Anderson. I decided to make this video so I can be able to put this message out there. I'm not going to get off into everything that's going on. I've been down for 20 years inside this prison. I just found out in 1996 when a former friend of mine went down to the Sacramento Superior Court, and then when she was asking for all the records of my case, they waited for about 90 days before they actually gave her some form of documents. So while she was looking inside all the Pacific documents, she ended up coming across this document right here. I don't know if you can see it. I don't know if you understand it. But what it is, and I'm going to read it to you. It's from the Sacramento Superior Court. And it's an order for disposal of all criminal exhibits. It has the judge's signature, and it has the date of May 29th, 2002. This is the other document, same exact Pacific thing, instructing them to destroy all the evidence that was used against me. Now I'm going to tell you this. This same judge, I went pro per in 1999 during my trial. I was innocent of all the charges. They brought the victims. None of the victims identified me. My only silliness of it was I went pro per by myself. I didn't know no law, but I believed it in the system. I'm only 20 years old. I thought the system could be trusted. I thought I can trust a judge because the judge knows the law. I'm thinking this is America. This is the way I was raised to believe. Didn't even realize this judge found me guilty of 17 counts after putting a jailhouse informant inside my cell that I never incriminated myself on anything. I thought initially I was being arrested for something totally unrelated to the charges in which I was convicted for. But a situation that I didn't know about. This man used that information, told the DA, which I didn't even know him. The DA ended up coming back, re-fingerprinting me a second time. And after that second fingerprint, they used it, them set of prints right there in order to then say I was the one who committed this home invasion out there in Rancho Cordova. When the lady identification technician came inside there, I questioned her and said, can fingerprints be manipulated on latent cards? She said they can. It was on transcript. I asked the crime scene investigator about the same issue, if whether or not he took any photographs or did he preserve the tape. He said he didn't and didn't take no photographs. There was nothing to substantiate those latent cards. But besides the judge looking at the reality, he sentenced me and convicted me on all 17 counts and gave me 49 years when I was only 20 years old, at 21 years old at the time. 49 years and there was no witnesses, no victim. On the day of the crime, the victim did not identify. I had on tan color clothing. The police officer got on the stand and said tan cannot be mistaken for black at nighttime. I was not identified. And the crime occurred right on the same street as my parents lived. Sent to 49 years. My appellate attorney would not raise it. When I did file a habeas corpus back inside the Superior Court, first in 2001, it went to my trial judge. He denied it because my appellate attorney wouldn't bring it up on appeal. Wasn't my fault. I didn't know law. Second of all, when I came back and filed it in 2004, it went right back to the same trial judge. The whole time he fraudulently knew he had been destroyed all the evidence. I wasn't even supposed to have this document. 2016, when my friend finally went, asked the judge about it. Asked the clerks about it. They gave her all these documents. She's making copy. When I told my attorney that I have on my youth parole eligibility hearing, which is this September 14th, 2018, I go next month. We initially told him, we showed him the document. He said, Anderson, you're not supposed to have this. But he's wanted to charge me now $20,000 in order for me to now file this inside the Superior Court. This being evidence for my release. So 2017, I decided to file it in the state court. When I filed my first habeas corpus, this is what I filed. It was stamp marked, postmarked it, dated, everything. I brought it up under newly discovered evidence. The judge that they put on it was not my same judge because he retired. But they denied it under Henry Robbins and Henry Clark, saying that I had exceeded my timeline. They refused to even acknowledge it. But it's newly discovered evidence, and the Senate bill just got passed, Senate Bill 1134 in 2017. But they didn't acknowledge it. So when I did refile the petition for reconsideration, I don't want to get to showing you all these documents. Here's my petition for reconsideration. He denies it and specifically tells me that I should have mentioned it. This is his response right here. He tells me petitioner did not claim in his habeas corpus petition that he has recently become aware of newly discovered evidence of an exonerating nature. That was the caption that I had on my petition. Newly discovered evidence. They turned a blind eye. So I filed a petition for writ of mandate, California, to the Court of Appeals. They denied it in 6 days. I filed to the California Supreme Court, petition for review. They played a game on me because I had only 10 days to file the petition for review. But what they did, the courts of appeals did, they waited till 8 days in order to serve me that document. So I got it late. And I'm thinking generally the time to when you need a file is on the date you receive it. They didn't do that. They played me by the technicality. At this time, I've been learning law. Passed the California Supreme Court. I then just filed it to the United States District Court. United States District Court just got back at me on 2 separate occasions. First, they denied me and said it was successive and that I need to seek pre-certification from the courts of appeal. I said, okay, because I did file earlier on the same issue, but this is newly discovered evidence. So I filed a Rule 60B motion, which gets around that pre-certification from the Ninth Circuit. I filed it on 2 separate occasions. First, they accepted it as an objection to the magistrate, so I refiled it. Then they turned my Rule 60B into a Rule 59E, which is asking for a new trial. So then I refiled on June 28th, letting them know this is not a Rule 59A, a Rule 59D. I'm filing a Rule 60B motion, which is fraud, newly discovered evidence. They turned around and kept my thing as a Rule 59. Didn't even acknowledge the newly discovered evidence. I've been sitting in here 20 years, and these people had already destroyed the evidence way back in 2002. All my habeas corpus that I filed, all my court proceedings was all done fraudulently. I'm an innocent man still sitting up in here, and they have no evidence, no court transcripts, no evidence since 2002 from the very same judge that convicted me. So instead releasing me, they decided to turn a blind eye. So the only way for me to fight back is to put this out there to you. Make this shit go viral, because it can be your son, it can be your daddy, it can be your mother. They're destroying evidence by the judge's own John Hancock, and we don't know nothing about it. If you don't make this stuff go viral, if this same repeated theme going on, evidence being destroyed, and we don't know nothing about it. District attorney is playing like we got all the evidence. They don't got nothing. In a lot of our cases, I've been down 20 years. In AB 79, the legislative language that they use, they destroyed all my stuff in 2002. And I'm still here. Just now came across the information, and they're turning a blind eye. So if I can't trust the justice system, I have to put this information out in your hands. Make this video go viral because it can be your sons that's in the institution and you don't even know it. Just like what's going on in Charleston, Virginia, and they impeaching these Supreme Court judges. These judges in California need to be getting impeached for abuse of discretion and turning their blind eyes towards what's going on to the people in prison, because we getting stuck and they're using these technicalities in order to keep us from being able to have our issues heard. So I got to do a desperate situation and put this in your hands. Make this shit go viral. Because if you don't, they're going to keep doing the same damn thing. I go to a hearing September 14th, 2018 for a youth parole eligibility parole hearing. But it ain't guaranteed they're going to release me. The system is corrupt. I'm innocent sitting up in this damn thing for 20 years.